Pat, your mic is turned off.
We're on YouTube, Your Honor.
All right. We got Mike. We're good to go?
Yes, Your Honor.
All right. Good morning, ladies and gentlemen. Welcome back to Bexar County Court at Law number 6 and the Bexar County Veterans Treatment Court. Today is Wednesday, the 9th of February, 2022. Today is our motion to revoke probation docket. On my docket for today, our cause 659-538, State of Texas versus Lee Flores, represented by Mr. Marshall White. Mr. White, are you ready to proceed? And Marshall, your microphone is turned off also. There you go.
Judge, I'm ready to proceed. Miss Flores is available.
Okay, I don't have paperwork for you with regard to a defendant's consent to motion to revoke hearing by video conference or a trial court certification of defendant's right of appeal. Did you get those?
I submitted the consent. Maybe Ms. Flores. I'm not sure if she needs to go over those at the jail. But as far as the certification is concerned, Judge, we have an agreed recommendation. Okay,
that's all well and good, but I need these two documents signed just because my staff attorney, Brooke, tells me I do, and for no other reason.
Well, I think Brooke's wrong, Judge.
I have two. I have defendant's consent to motion to revoke hearing by video conference, and all that does is say I consent to having this hearing by video conference instead of in person. And the second one is trial court certification of defendant's right of appeal, which in this case is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal, unquote.
Right, yeah, that's not where we're going. I mean, I spoke with Eddie, that's not where we're going. The consent form, I think, is appropriate, but the certification is not.
And why is the certification not appropriate when it's a requirement of law?
Well, how is that? That's if you're getting adjudicated.
Yeah, but you don't know right now, and I don't know right now whether or not she's going to be adjudicated. If you have an agreement with the state, as you're well aware, I'm not bound by it, and I may not follow it.
Well, again, I mean, it seems circular. This is the state's motion. They want to continue her on probation.
And they're welcome. I understand, and they're welcome to recommend that. But as you of all people are well aware, since you've done this a million times, I'm not bound by any agreement you may have with the state. I will certainly be happy to listen to your recommendation. And the state's recommendation and the probation department's recommendation, then I'll make a decision. Just like
that's incorrect. This is circular. That's incorrect. Okay, that's incorrect. This is circular. This is the state's motion. This is a state's motion. It's not your motion, Judge. It's a state's motion. And the state wants to continue her on probation. It's not your motion.
Okay. You got to understand. Bear with me now, Marshall.
I have bear with you.
As a matter of law, it's not the state's decision. Once they file the motion, see, in this particular case, it's a motion to enter adjudication of guilt and revoke community supervision. Now, they have absolute authority to withdraw that motion if they wish to, just by making a motion to withdraw it. If they don't withdraw it and the hearing is held, as a matter of law, I do not have to honor any plea bargains or agreements between the state and the defense. I'm not saying I'm not going to. There are many, many occasions I go along and do exactly what y'all have agreed to, but I'm not bound by law to do that.
Yeah, and yeah, like I said a moment ago, this is circular. And I've already said this to Mr. Villarreal. This is circular. Okay.
I don't understand what circular means. What does circular mean?
Circular means you file a motion to revoke her probation, but you turn around and recommend that she could be continued on probation. That's circular.
Okay, I never heard that, but now I've learned something. Obviously, the options in this case, best I can tell, are A, I just continue her on deferred adjudication probation, or B, I order her probation or deferred adjudication probation revoked and keep her on regular probation, or C, I revoke her deferred adjudication probation and find her guilty of the offense and sentence her to some sort of jail term in lieu of putting her back on regular probation. Those are my three options under the law that I'm aware of.
Okay, Judge, I mean, look, I guess we'll go on the record. I'll state my objections for whatever appeal purposes Ms. Flores may have about this matter, because I think it's circular. The state's going to recommend this matter the motion should, I mean, and you mentioned it a moment ago, as far as the state's option is concerned, and I raised it to Mr. Villarreal that the motion should be withdrawn, and we should not have even wasted the court's time alter and amend her conditions pursuant to our agreement and move on with this.
And that's totally up to the state. State, at this time, are you making a motion to withdraw your motion to enter adjudication of guilt and revoke community supervision and cause number 635353 with Mr. Joseph Nathaniel Munoz?
No, Judge.
All right.
Your Honor, that's not the right person. It would be Leah Flores. You just said Joseph Munoz.
Let me try again. I have several here.
I know.
All right, State, I rephrase that and I apologize. I mistook it. I've got too many sitting here. State, with regard to cause number 659538, State of Texas versus Lee Yvette Flores. This is a motion to enter adjudication of guilt and revoke community supervision. And Mr. White is indicating that you have an interest in making a motion to withdraw your motion to enter adjudication of guilt and revoke community supervision on Ms. Flores. Is that true?
That's not true, Judge. I have no intention of withdrawing this motion.
First of all, that's a mischaracterization of what I said, Judge. I said I spoke to Mr. Villarreal about that, and he declined to withdraw that. That's why we're here. So I mean, that was a mischaracterization. So
okay, I misunderstood.
And for him to say it's not true, it makes it sound like I lied, and I don't appreciate that.
No one's accused.
This has went off the rails this morning. It's because it's circular. This is off the rails.
All right, Marshall, stop talking for about 5 minutes, and you can talk all you want. Okay, you and I've been friends for 30 years. We've never had any problem. If I if I didn't understand what you were telling me, that's my fault, not your fault. We're all good. So at this point in time, all I need to understand is, are you and Ms. Flores ready to go forward on this motion to enter adjudication of guilt and revoke community supervision today? And are you willing to fill out the 2 forms we've been talking about so we can do that? Or do you need more time? Because if you need more time, I'll be happy to give it to you.
Judge, I already did my part. I'm not holding that part up. I mean, maybe they're over at the jail. The paperwork's over at the jail. I'm not holding that part up, Judge.
Okay.
I've already submitted those 2 papers, even though, I mean, I did those 2 documents before I talked to Mr. Villarreal, because
Okay.
that's just routine business for me, is to send those papers, but again, having discussed the matter with him, I know he's green. That is new. That's why he's in your court. He's a misdemeanor district attorney, and like you said, I've been doing this a long time. And normally on a circumstance like this is you withdraw and amend these motions to revoke when you have an agreement for continuation on probation. There's no change. There's no material change, okay, in the situation. This is not a revocation, put her on probation, revoke her on a deferred and put her on probation. This is a straight continue her with these recommendations. So I mean, if I need to go back in the breakout room with Ms. Flores to move this ball, that's fine, and get this paperwork done. But that's the way this should be done.
All right. Let me tell you what my understanding of what the law requires us to do. And obviously, you're a defense counsel, and you're a damn good defense counsel. And your interpretation and my interpretation and Mr. Villarreal's interpretation may be different. Here's my understanding of what the law requires us to do. In order to have a valid motion to enter adjudication of guilt and revoke community supervision hearing by Zoom, which is what we're doing today, I need signed by both you and Ms. Flores a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, and also the document entitled Trial Court Certification of Defendant's Right of Appeal, which has previously been marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal, unquote. And I agree with the defense. That is a worst case scenario at the outcome of this hearing. I have not made a decision on this hearing. I've not heard any evidence. All I did was read through the MTR and the allied documents that Ms. Gross sent me from CSCD. So I don't have any preconceived notions on Ms. Flores. I understand that Mr. White is telling me that he and Mr. Villarreal, who is our assistant criminal district attorney, have conferred about this case, and that Mr. White's understanding is that Mr. Villarreal is going to recommend continuing probation. Is that correct, Mr. Villarreal?
Yes, Judge, with some altered conditions.
Okay. But Mr. White, I'm not bound by that, as you're well aware. So my request to the defense at this time is you go back and chat with Ms. Flores to make sure she understands, because our conversation, I apologize, Ms. Flores, has probably been confusing for you this morning, and explain once again what we're doing, Marshall. And if she wants to go forward today, we can. She just needs to sign these 2 documents, and you need to sign these 2 documents and send them back to Pat, and I'll get them, and we'll go through it today. there's no, even though that you and the state may have an agreement and both of you are going to recommend continuation of probation, that does not bind the court, i.e. me, in not revoking her if I feel that's in the interest of justice. So I understand, Mr. White, you're doing the best you can to maintain control and do the best you can for your client. Nothing wrong with that.
This is a procedural black hole that's circular. Okay, like I said, I disagree with you. It's just a matter of Mr. Burrell not withdrawing the motion. That's it. Period. There's no difference. So at any rate, and back to, it keeps, misstatements keep being made. I've already signed the documents, Judge. This is not a matter of me, the court waiting on me to sign the documents. I already signed the documents. One document was unnecessary because you have not made a decision. So the certification document is not even necessary. It's not even necessary. So at any rate, I've already signed it.
Okay, Pat, how do we get these documents? I don't know if Ms. Flores has had a chance to execute them or not.
Ms. Flores just needs to pull them up and sign them. She may get a deputy who might help her pull those up. And then once she signs them, Your Honor, that's it. But it's on her, on that notepad, on the laptop that she has. The deputies would be the ones who would know.
Okay, I could go back into a breakout room and try to shepherd that process.
Okay, all right. And I will put you in room 3. Ms. Flores will go to room 3. Ms. Flores, join a breakout room. There should be a button that says join on the bottom, maybe. Go into a breakout room and then ask them for the paperwork. It will show your name first. All right, Your Honor, they're gone. You can continue with
Okay, next on my hit list is cause number 635353, State of Texas versus Joseph Munoz. This is a motion to enter adjudication of guilt and revoke community supervision. And I would ask Ms. Benavides at this time if she's ready to proceed.
Judge, I'm just don't want to be on your hit list. Other than that, we're ready to go forward with a plea of true with an explanation.
On my kindler and gentler not hit list is Miss Alma Benavides representing Mr. Joseph Munoz in clause 635353. Would that be more accurate and more palatable for the defense?
Yes, Your Honor.
All right. Representing the state is Mr. Eddie Villarreal, Assistant Criminal District Attorney. Representing the Bexar County CSCD is Ms. Susan Gross, who I will swear at this time. Ms. Gross, would you please raise your right hand? Do you swear the testimony we're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Okay, once again, this is clause 635353, State of Texas versus Joseph Munoz. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I have for Ms. Benavides and Mr. Munoz to identify their signatures on is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. And in fact, Mr. Munoz, is this your signature on this document, sir?
Yes.
Thank you. And Ms. Benavides, as attorney for Mr. Munoz, is this also your signature on this document?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal, unquote. Is this your signature on this document also, Mr. Munoz?
Yes, sir.
Thank you. And Ms. Benavides, as attorney for Mr. Munoz, is this also your signature on this document?
Yes, it is, Your Honor.
Ms. Benavides, my understanding is that this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, Your Honor. He's pleading true to violation of condition number 2 and number 13, and not true to number 14 with an explanation.
You are not requesting a contested motion to enter adjudication of guilt and revoke community supervision, correct?
Correct.
So, Mr. Munoz, your attorney has represented that you are going to enter a plea of true, and I'm just going to say with an explanation, to conditions 2 and 13, and not true to condition 14, all with an explanation. And on my copy of the motion to enter adjudication of guilt and revoke community supervision, I have 2 number 2s, which for the record, I'm going to call 2A and 2B. both alleged positive urinalysis tests, I guess, for marijuana, one on December 20th, 2021, allegedly, and one on November 23rd, 2021, allegedly. And is it my understanding, Ms. Benavides, that Mr. Munoz is entering a plea of true with an explanation to both 2A and 2B?
Yes, Your Honor.
Okay, and number 14, and that's fine. Okay, Ms. Gross, would you please advise the court and the parties of the status to Mr. Munoz's probation?
Yes, Your Honor. Mr. Munoz has been reporting as directed. We last saw him on January 25th, 2022. We do not have completion of any of his 48 hours of community service. His case is paid in full. He was ordered to take the drug offender education class. Although we have no paper certification, he did provide a photo to this office showing that he completed the class on February the 4th, but has not yet received his certificate. He has had 2 positive drug tests, both for marijuana. He has one that is pending, where the sample was given on Monday. His original test results were at 210. His second test results were at 94, so his levels are coming down. His prior arrest history is a possession of a controlled substance, penalty group 1, less than 1 gram, and possession of a controlled substance, penalty group 1, 1 to 4 grams. This is his first violation report, first MTR, and his officer is recommending that he be placed on weekly drug testing via the IVR call-in line.
And are you telling me the last urinalysis test we have on Mr. Munoz before this last Monday, which I guess was February the 7th, 2022, was in December of 2021?
Hang on, I got it up right here. I just got to get to that screen. Okay, he provided a sample on November the 23rd and then on December the 20th, and both of those were positive. And then he provided one on February the 7th.
So why a gap between December of 2021 and February of 2022?
I'm not sure why there wasn't one done in January.
When are you going to get the results back on the
Next
urinalysis
week.
test conducted on Monday, February 7th, 2022?
Next week.
Okay. Ms. Benavides, what are you requesting?
Your Honor, we're respectfully requesting that you continue Mr. Munoz on his deferred adjudication probation. He is paid in full. He provided a receipt this week. He's waiting on the actual certificate for the dope class, but he did take a screenshot and we did provide that to probation. So he has completed that class. We're just waiting on the certificate. He tells me he's not going to be smoking marijuana anymore while he's on probation. So that's, but we're waiting on the latest results. He did do some of his community service hours, but he's still working on that. So we're asking the court to continue him on his probation and perhaps do weekly UAs, if the court would feel that would be appropriate.
Let me back up, if you don't mind, to your community service hours. How many community service hours has Mr. Munoz either completed or donated $10 per hour to a court charity to get credit for community service hours?
I believe he's done 4 hours, Your Honor.
Ms. Gross, does that sound right?
We have no record of any hours being completed, Judge.
Understand. Okay. Hey, Mr. Munoz, is this your urinalysis test you took on Monday going to be positive for marijuana?
No, sir.
All right, let's state, what is your recommendation going to be? Or are you going to wait and I'm going to wait and get the results of the UA, and state you may want to do that too before you make a recommendation. But I think we all need to know what that is. And I hope Mr. Munoz is right and is negative, because that will make everything easier on everybody. Susan, if we reset to next Wednesday at 10 for the other MTR hearings we have then, to make a decision on this case? Will you have the UA results back by then for sure?
I don't know, Judge. I'm not the lab. I don't know what their workload is, and we have no control on how long it takes. Those tests get sent out of state to Arizona.
All right, but you have some sort of general idea how long normally they take, do you not?
Correct. And yes, it should be back, but I can't honestly say if it's going to be back.
If it's okay with the state and the defense, let's tentatively reset this for sentencing or not sentencing, depending on what the result of the UA are, for next Wednesday at 10 a.m. Susan, if you don't have the results by then, Alma, we're just going to reset for the following Wednesday until we get the results back. Is that okay with you, Mr. Munoz?
Yes, Your Honor.
All right, is that okay with you, Ms. Benavides?
Yes, Your Honors, just to clarify, 10 a.m. on February 16th.
Correct. And that could
Okay.
change if Ms. Gross does not receive the results back by then. We'll just have to reset again and we'll let you know.
All right,
Okay.
Judge.
I want to be fair to Mr. Munoz, and if he really truly has stopped smoking marijuana, that will be reflected in the results of this test.
Yes, Your Honor.
All right, that's the plan. So thank you guys, and we're just going to reset for next Wednesday and find out what the results of that UA are.
Thank you, Judge. May we both be excused?
And
Thank you.
Mr. White, did we get
Thank
Mr.
you.
White's documents done? I haven't looked at my computer to see.
Judge, I spoke to Ms. Flores, and the bailiff has indicated to her that he cannot locate the documents. He suggested, Pat, that you send a reminder over there to the jail.
Okay,
I've done my part before we came on this morning at 10 o'clock, so I don't know what's going on over there at the jail with the email, so.
okay, I will do that right now.
I know the consent, I understand the consent form is necessary, so, I've already done that, and so.
All right. Thanks, Marshall. Just stand by if you would, and we'll take up Mr. Martinez's case with regard to Mr. Sanchez, and then we'll be ready for you if, as, and when we find the document. Worst case scenario, we can reset a week if we have to. Okay, this is cause 662-066, State of Texas versus Joshua Sanchez, represented by Mr. Luis Martinez. This is a motion to enter adjudication of guilt and revoke community supervision. Mr. Martinez, are you ready to proceed at this time?
Judge, I just got on. Unfortunately, I was running late. I had to be in person in Seguin. So I've not conferred with probation or the state.
Take as much time as you need and confer with probation in a chat room and or talk to your client or whatever else you need to do right now. We got plenty of time.
He's here with me, Judge.
Okay.
Okay, thanks.
So do you want to go into a breakout room with Ms. Gross at this time?
Yes, please. I just need 2 minutes with her.
Let's do that.
Okay, and I just set the reminder, so for, okay, Susan, let me move you to 4 and Lewis 4.
Mr. Munoz has a question.
Yeah, yes.
Have we got Ms. Benavides online with us so we can all be together?
Yes. Oh, no, Ms. Benavides left. What is it that you need, Mr. Munoz?
I just wanted to ask about the community service. I could pay the $10 an hour at a food bank, right? The San Antonio Food Bank.
Not necessarily the food bank, but there's several other organizations. I mean, let me let your attorney explain that to you. Yes, the answer to your question is yes. Normally, the specified court charities are Special Operations Wounded Warrior Organization and Family Violence Prevention Organizations. Instead of
Mr. Munoz, your officer should have a list of the places where you can donate.
Okay, thank you. I'll
Yes,
get in
that's
contact with them.
Okay, sir.
Thank you.
Okay.
Eddie, what I told Pat we're going to try and do to catch up on, I have that big long